I'm sorry, I have to pass out the latest.
Nice. The latest
version.
The few more days sort of thing.
Not me.
Sorry.
Thank you for doing that.
Oh, I don't know if I have enough of this for everybody.
Here, I can look online.
Oh,
All right.
Wow,
Kenny.
it's a thick one.
Okay, we're live and welcome to the House Judiciary Committee this afternoon, continuing our work. February 12th, we're going to be looking at H 578, draft number 3.1, the act relating to penalties and procedure for animal cruelty offenses. So we have the last 40 minutes that we are going to be spending on this bill, except for voting it tomorrow.
Sure.
Unless there's something dramatically wrong or a tweak. Because this bill needs to either get voted out tomorrow morning or go back on the wall for next year. So just for everybody to understand that that's where we are, because there's other things we have to get to. But I think we're there. I think it's in really good shape. But over to you.
And this bill has to go to two other committees, is it?
It's going to have to go to, agriculture's already looked at it. Got some additional testimony today. I haven't heard anything back from them. GovOps did look at it and voted 803 or something in favor. You know, they looked at the very last section. And it does
The most recent draft.
well, the stuff they have to look at was not. It's the very last section.
Yeah. That makes sense.
Yeah.
What's changed.
Yeah. So and but appropriations needs to look at. Does have money in there for appropriations. So with that, over to you, Eric. If you could run through the final changes on that.
Yeah, sure, will do. Good afternoon again, everybody. Eric Fitzpatrick with the Office of Legislative Counsel. As Chair Lalonde said, we're now looking at draft 3.1 of the House Judiciary Committee's proposed strike-all amendment to the bill as introduced, an act relating to penalties and procedures for animal cruelty offenses. The number of yellow highlighted changes has decreased dramatically with each draft, so there really aren't that many in this version of it. So I will focus on those changes unless there's any desire for anybody to review anything. So feel free to stop me if I'm going too quickly. But again, drawing the committee's attention to where there are language differences between this draft and the previous 2.1 that the committee had looked at. The first one is down on page 5. And this has to do with the misdemeanor animal cruelty offense. Remember, animal cruelty has both a misdemeanor and a felony type of offense. And the misdemeanor offense in particular has a long list of the types of conduct that constitute misdemeanor animal cruelty. You've added a couple as the draft has been working its way through. And there's a couple of language tweaks to the new offenses on page 5. One of them has to do with it's a misdemeanor offense if someone, while they're prohibited from possessing, owning, caring for, or residing with, or having custody or working with an animal, if they do any of those things while they're prohibited from doing so by a court order, then that is a new misdemeanor offense. So the language changes on line 6. So basically, it's a violation of that provision if you're doing any one of those things while you're prohibited from doing so by any court order. It doesn't have to be one that's just issued pursuant to the animal cruelty chapter, but you could be prohibited, for example, by a conditions of release order or by an order in relation to a relief from abuse, or any one of those types of proceedings could also conceivably include a prohibition on this. So you violate any one of those orders and it would be a misdemeanor violation. So that's that change. Right below it, you'll see we've done this in a couple of other places. For example, line 1, establishing a knowingly a mens rea, so that in this case, if you're refusing to comply with a court order to permit periodic unannounced visits, you have to knowingly do that. In other words, you can't inadvertently have failed to comply with the order and therefore be violating the statute. You have to know that you're violating it in order for it to be a misdemeanor offense. So those are those two. Moving down now to exactly kind of what I was just referring to, which is, you remember that in addition to the criminal offenses, the existing statute permits the court to impose a number of other types of sanctions. Those can involve forfeiting possession of the animal, forfeiting any rights in the future to possess other animals, allowing periodic unannounced visits by the animal control officer and others. So within that section is where the next round of changes are, and that's sort of, it starts over on page 9. This has to do, sort of toward the bottom of page 9, it has to do with what I just mentioned, the fact that one of the things the court can order if you're convicted of animal cruelty is that you look at lines 12 and 13 there, you forfeit any future right to own, possess, care for, reside with, have custody of, or work with any animal for a period of up to 5 years. I remember that the committee had done work over the last couple of drafts to make sure that that language, have custody of, work with, etc., is consistent throughout. So you'll see that's added on line 20, again, to make sure that it's consistent in each instance. In that case, it's with reference to the livestock or poultry exemption. Again, the idea that you won't forfeit any future right to work with, have custody of livestock or poultry on the basis of an animal cruelty offense, unless the offense was against, you'd committed animal cruelty against livestock or poultry. So that's carries forward that clarification that the committee was making. Over on page 10, now we're still in the sanctions that a court can impose in addition to the criminal sanctions. And this has to do with the topic of education, counseling programs. Remember, that also is existing law, that you're not adding something that doesn't exist already, but you are making some modifications to it. And you'll see, for example, line 3, the original language is participate in animal cruelty prevention programs. You had in the last draft had successfully complete, but I think the committee heard that that was a hard thing to enforce successfully anyway. So now it just says complete rather than successfully, and clarifying that the program is one that is approved by the Director of Animal Welfare. That's in respect to animal cruelty prevention programs. The next Romanet number 2, is the, you'll see the successfully complete change is made again. And then also clarifying that with respect to these animal abuse education accountability programs, you're making it clear that if any are approved by the Director of Animal Welfare, then they could be required. I think the committee's understanding was that there may or may not be some that are approved at this point. Moving on to the counseling element in Romanet 3. Again, this language is really, and actually the change here between the previous draft and this draft, just skipping down a little bit to what was Romanet 2 there. In the existing law, the counseling language is different for juvenile offenses and for adult offenses. So what's being done here is you're striking the separate procedure for juveniles and just making it consistent, whether you're adult or a juvenile, it's the same thing. And so that language is really, a bunch of it is moved from the juvenile section right up to here to Romanet 3 lines 9 through 12 and tweaked a little bit. But it would apply to both adults and juveniles, same idea. So the court could order, again, this is discretionary, not required at this point because it's the misdemeanor offense, undergo a psychiatric or psychological evaluation. And if the screening indicates that therapy is needed, obtain psychiatric, psychological, or mental health treatment with a licensed clinician, and then making clear remotely or within a reasonable distance from the defendant's residence. So the treatment could be remote or in person. Either way would satisfy that.
Will you take questions now? We have a question from Angela, I believe.
Hey, Eric, this language is, I realize it's not new language, but it's just striking me as a bit odd that within a reasonable distance from the defendant's residence. Is that necessary? I mean, it's, who's determining reasonableness, and are we, what if they wanted to attend in person, not remotely, but it was like an hour from their house? Is that it just seems like odd language to include.
Yeah, it's been there a long time, so I can't really say whether it's caused any issues or It predates me. So,
And that helps include New Hampshire, or the other states.
But what isn't, I would want to say you can go anywhere you want, is, if they're like a licensed clinician, we're limiting it by saying within a reasonable distance. Seems odd to me.
We're gonna keep it. It's been there for a while.
But people aren't really using they haven't been, okay.
Keep moving. We are in version 3.1 and it's existing language.
So easy to get rid of. Okay, I think it's silly. Let the record show.
The record reflects. Record reflects.
Carry on.
moving along.
I'll talk to the Senate.
Oh my God. There you go. There's always the Senate. Everybody should
Please take
remember,
this language out.
always the Senate.
All right.
We're moving now over to the next page, page 11, and this is another one of those sanctions that the court can order. Remember, this is starts on line 5. These are unannounced visits by a humane officer in the future to inspect the person's treatment of animals in the future. And a couple of changes you make here. First of all, you add the director of animal welfare to the people who can conduct these periodic unannounced visits in the future. And also the time limitation on line 5. So rather than say that those unannounced visits can only last for a year, leaves it up to the court's discretion to decide how long those can be extended for. But again, line 14 and 15, the court always has the option to, under existing law, it had been extend that 1 year period, but here, just the court can increase it or decrease it. Is what the intent was. So you just replace the word extended with modified. So the court can always modify whatever period it chooses in the initial order. Moving on from there, let's see. So those are, as I say, if you look over on page 12, the same language we just saw with respect to the misdemeanor sanctions the court can impose. Here for the felony ones, it's just the same language, expanding or making consistent the language about having custody, working with, et cetera, so that it's consistent throughout the bill. Moving on quite a bit now down to page 14, and this is the piece where, again, it's really just making this language consistent throughout the bill. In this instance, it's the language that deals with the ability of a person who has been prohibited by one of these court orders from, possessing an animal in the future or that sort of thing, residing with, working with, et cetera. Remember, he created a court process where the person can file a petition to be relieved from those restrictions. So this language is just chewing up the language in that petition process, again, with the underlying language about what the person can be prohibited from doing. So again, you see line 8, removing the word successfully, as you just did in the underlying statute, pointing out that the approval of the director of animal welfare is relevant because that's also part of the prevention and education programs piece that you just looked at. Again, chewing up the psychological and psychiatric counseling language as well, so that, again, it's just making sure that the language for purposes of this petition that the person is able to file is consistent with the language of the underlying prohibitions.
Yeah.
Now we're moving on to the forfeiture piece. So this is the other, one of the other big parts of this bill, which is the expediting of the forfeiture process. So again, this is different from the criminal misdemeanor felony crimes, as well as different from those sanctions we were just talking about. But in addition, there's a civil forfeiture process that exists in existing law. And the committee has been redrafting this over the past several drafts in an attempt to clarify and expedite it so that it can move along in a speedier fashion and not increase the costs for both on the animal for being held for that long and on the rescue organizations that are holding the animal. So some amendments in this draft to that process start on page 16. remember when that, and this is the situation where uh, uh, a warrant can be issued for a humane officer to seize an animal that's being subject to abuse. And this idea of that when the humane officer executes the warrant, existing language starts on line 10, provides that a veterinarian must accompany the humane officer during the execution of the warrant. Here, you're basically keeping that language. That's line 11. So it'll be existing law, but adding that a failure to be accompanied by a veterinarian during the execution of the warrant shall not be grounds for dismissal of the enforcement action. So that's kind of similar to the Secretary of Agriculture language that you added. So that, again, if the Secretary of Agriculture isn't consulted, I think it was State's Attorney Scott Brown who pointed out that there was a Vermont Supreme Court case that said, well, that's not fatal to the claim. So this is just doing the same thing here. The enforcement action doesn't have to be dismissed just because a vet didn't accompany the humane officer. Moving down now to page, let's see, I think we're going to page 19, yes. So now we're at this new expedited proceeding of forfeiture, and this you'll see some changes here. And this is, the idea is that when a humane officer seizes an animal, and again, I just mentioned a warrant process, but there's another process, which I'm sure the committee recalls, which is that if there's an emergency situation where it appears to the officer that the animal's in a life-threatening situation, the humane officer can seize the animal right away without having to go to court and get a warrant first. And this language applies in those sort of situations. And how might the forfeiture proceeding work in that context? And you'll see that the way it works is starting on line 1. Generally speaking, unless someone who has a legal interest in the animal requests a hearing and post security within 14 days after that initial seizure, and the procedures outlined here are followed, then the animal will be forfeit. Now, again, the new language you see on lines 3 and 4 is making clear something that you had already agreed upon and was in the previous draft, just making it clear that, again, for consistency's sake, that the process that you've created here permits the defendant, the person whose animals are seized, to request a financial hardship exception to this requirement that they post security. I'm sure everybody remembers that piece. We've been talking about it a lot. But in order to be accurate, that sentence needs to also state that the animal is forfeited unless the person requests a hearing and provides the security, unless they've also requested for a undue hardship exemption to the security requirement, all within that 14-day period. So you'll see as we go through, if they don't do any of that, if they don't request a hearing and they don't request the financial hardship exception right then within that 14-day period, then the animal gets forfeited. If they do request either or both of those things, then you'll see, and you probably remember, the hearing has to take place within 30 days. And at that hearing, you'll see the clarifying language in here on this as well. At that hearing, the court not only decides whether or not the animal should be forfeited, but also whether or not the financial hardship exemption should be granted. So in other words, there's not going to be some separate court process, some separate hearing, some additional layer of procedure. It all gets done at that one court proceeding that has to take place within 30 days after the seizure. Now, another reason you may recall, let's go on to down here, and this is lines 14 to 16, also very important. Remember in the previous draft, because you had this issue of, well, that's all well and good for the person who's physically present when the animals are seized, because they're actually handed the notice. So they're getting due process fulfilled because they're getting a notice that the hearing, they got 14 days to contest it or request a financial hardship exemption. And the previous draft had said, well, if they're not there, then they have to be served under Rule 4. And that involved, the sheriff, personal service, first-class mail, and posting is permitted under Rule 4. But the way Rule 4 works, the other options have to be tried first. So the more expedited approach that this draft takes, you'll see, is that it doesn't require personal service if the person isn't there. However, service is accomplished by, and you see line 15 and 16, by conspicuously posting the notice in a prominent and accessible place at the location where the animal is seized. So that will give the person notice as the language makes clear, in a conspicuous place where it's very accessible and prominent, that again, they have 14 days to contest or to request a hearing or to request financial hardship exemption. And if they don't, then the animal gets forfeited. And I think that the conspicuous posting requirement is also under the facts is a good argument for that being satisfactory under due process as well. So that's another avenue for doing it. And that way it also helps you keep the process moving in an expedited fashion. And then so to be consistent with that, I'm over on page 20 now. That's what I was just mentioning, that the clock starts ticking, the 14-day clock starts ticking for the person to contest it. I'm looking at line 4 now, page 20, on the date of that seizure. Because the seizure, on the day of that seizure, they're getting notice. Either it's getting handed to them or it's getting nailed to the wall or the door or some other prominent place. One way or another, they're getting notice on that day. So the 14-day clock starts ticking right then. Making clear now on the same page, I'm on line 20 still. If you look at page lines 15 to 17, again, just clarifying that same hearing, either or earlier, the court could always resolve the financial hardship request earlier, but if they don't, then at that same hearing, they also have to decide that issue in addition to the merits. So that's all in that new sentence, lines 15 to 17. Let's see, now we're over on page 21. Again, this is all clarification to be consistent with this process that we just described. See lines 9 to 12. Again, talking about the timeline of posting that security. It has to be posted within 14 days following the seizure, but have to be clear there that unless the person requested it reduced or waived on the basis of financial hardship, because in that case, then the court's going to have to decide that issue at the hearing. So it wouldn't be posted until that time. Lines 18 to 20 of that page, I think the committee had discussed that it didn't help the process, or it wasn't something that you wanted to continue to include, that this, whether or not they paid the security was something to consider at the hearing.
So
Line
just
22.
Before you go ahead, Eric, I just want to make clear with respect to that taking that language out on lines 18 to 20 does not keep the prosecutor from arguing that the inability to pay the security deposit or the security may be relevant to the fact that this person has neglected the animal. I mean, if the person isn't able to pay, it could be evidence that, part of the reason why the animal was neglected before was the person couldn't pay for the basic care. So, I mean, it's, in other words, I just want to make it very clear that that's an issue that if it's going to be relevant, the prosecutor will probably bring it up.
Yes, thank you. That's a good point. And I think I recall Judge Zoni making that same point, that in a given case, it could very well be relevant. And that the fact that the language isn't here doesn't mean that it can't be argued by the prosecution.
Thanks.
Yeah, thank you. Moving on to page 22, line 4. I think this was a correction we have recalled discussing in the last meeting. I think I'm going to return to Representative Arsenault again. I believe the word's correct where them was, but
Yeah.
I mean, offspring, yes, I think it's more correct. You could have a single offspring, but let's go with the.
right.
Offspring was
I'm going with work, although it has not been submitted to the proofers yet. So I'll be
We'll see
interested.
what they say.
Yes, I'll be interested to see what happens.
You're better.
You can disagree, I think.
No, what sounds better, but
Doesn't want any changes.
It's both a singular and plural word, so we are in tricky, tricky territory here, y'all.
It's very true.
So read this very
They
carefully.
might have fewer offspring, right? Fewer.
Now, we caught that one before, and you didn't catch the other thing about remotely and intersection. Anyway, go ahead, Eric, sorry.
No problem. One last change is over on page 26. I think this is the very last one. And that's line 16 to 18. And you may recall, so the previous draft, although you had decided I think, to strike the cost of care action. So that was a creation of a separate type of action that a rescue organization or humane officer could bring to try and recover the costs of care from the defendant. And I think the decision the committee made was, well, with this expedited process and the security being posted, that hopefully that was going to address the issue of getting these kind of costs paid for up front. But you wanted to make clear that the fact that that the forfeiture proceeding and the security was available does not mean that there couldn't be any other type of action that a person could file. And this is standard language that we've included in several places in Vermont statutes to when you want to make express the point that a person can still file a separate lawsuit if they have one to recover any sort of damage they have. That's the language you see here. The section shall not be construed to limit or infringe upon any other rights or remedies available under common law or any other provision of law or rule. So just making that clear. I think that's the last, yeah, that is the last change.
All right, any questions for Eric? Yes, Andrew.
Eric, do you know which style guide the editors use?
Not-
NLA,
no, I'm not sure. Off the top of my head, I'm not sure. I'm happy to ask though.
I would love to know.
Yeah,
Hello.
I will follow up on that.
Thank you.
You bet.
All right, Judge Zone, if you could join us.
Good afternoon again.
Yes, thank you for your patience in being here all afternoon.
It was a pleasure. So Tom Zone, Chief Superior Judge. Having in mind it is version 3.1, I would offer one comment only. On page 19, the service provision, where it allows the TAC order immediately, the public notice. I would be remiss if I did not highlight that generally TAC orders are permitted after showing of due diligence and the court considers the specific facts. That is rooted in due process considerations. And so I will not give a legal opinion on whether a TAC order immediately with no considerations of facts and circumstances or no showing of an inability to serve is constitutional or not, because that's something that would come before the courts. But I do think it's important to understand that that is something that you should most likely expect, that that's going to be something that differs from current Vermont law in a way that may certainly lead to challenges.
Appreciate that. I didn't see that coming. I appreciate, yeah, okay. Right,
And I won't weigh in on the was were.
right. No. I think you ought. All right, I appreciate that.
Yeah, that's all we got. Thank you.
Thank you.
Have a great day. Take care.
If Lisa can join us. Thank you for being back again.
Thank you so much for having me here. I'm Lisa Michelet, Director of Animal Welfare for the Department of Public Safety. And I know that you all have put a lot of time and work into this bill, and it's time to move on to other bills. With that in mind, I do have one tweak and then one sort of gap that I have suggested fill for, but happy to send language on and have you decide to discard it or not. So the first, the tweak is on page 21. It's lines 7 through 9. And it occurred to me when I was thinking about this, is the amount of the security and payment schedule shall be set in rules adopted by the Director of Animal Welfare pursuant to 20 VSA 3202E. And that is a great approach starting next legislative term. But if this is adopted as of July 1st, 2026, it means between that date and whenever you all can approve an administrative schedule by me, there will be no amount set. And so there's no security set. So my suggested tweak, gap filling tweak would be to, and I can send the language itself, but to end that sentence with a semicolon and state that until such time, the security shall be, and pick a number. It could be $100, could be $50 per animal. Just set something statutorily until it's possible to adopt that schedule. So that's the tweak. And then the other gap I noticed, and you might tell me to take it to the Senate, or you might tell me you might just fill this in however you want. But on page 23, if we look at the section starting on line 13, if an order of forfeiture is not entered after the hearing, the animal shall be returned to the person claiming an interest. But then we go down to, if the payment of costs required by the subsection is not made within 14 days after the final order, the custodial caretaker's costs not to exceed the amount of security posted shall be reimbursed from the animal welfare fund. It doesn't say what happens to the animal in that instance, because the caretaker has to pay the cost of care to get their animal back. And it says if they don't pay it, well, then the amount that is probably about $100 from the animal welfare fund can stand in for it. There are 40 states that have similar provisions where there's some sort of hearing, there's a cost determined, and the person can get their animal back or can maintain title if they pay that cost. And the way that those 40 states all resolve the issue is if the person does not pay the court-ordered cost of care, so the court could adjust what was put in, then title to the animal is forfeited. It's like getting a car back from being impounded. At this point, we've already had the hearing, and if your car is impounded, you don't get the car back if you don't pay the impound fee. And so that's the equivalent here. Happy to send you language that effectuates that's based on the statutes in the other states.
You can go ahead and send that, but this one might be
bigger than what.
Might need a little time in the Senate.
Yeah.
The other one, Eric, are you still with us, Eric? Is Eric still online?
Yes.
I am, but I'm not sure that approach works. I get the concept, but
on page 21 we're talking about?
Yep.
So yeah, that's what I was thinking. I mean, I didn't think that worked, but is there another way to have a particular part of this effective on a later date?
Or to say zero security until the schedule is adopted.
Well, I guess it would be zero because there would be no adopted schedules.
Okay. Yeah, I wasn't sure how that would get construed.
Okay, yeah.
So you see the issue though, Eric?
Yes. Yep. And we're on line 7 to 9 of page 21, right?
Right. That's not going to be in place for some time.
Right.
I mean, the one option, but I don't really like it, is we make that section effective July 1st, 2027, but I think we want to get this in place before that.
Right. I mean, we could ponder it. I mean, because if let's say the rules aren't in effect yet, then in a sense, the default is that there isn't an amount. That doesn't prohibit the court from setting an amount. But I suppose you could say, now that I think of it, did you say, Lisa, that I just picking out a number that I thought I heard you say? Well, that doesn't really cover the schedule issue. Because I was going to say, you could say shall be $100 until.
But that does fix it, because that sets it in the interim, and then once there's a schedule adopted, that overrides that interim.
Right.
We just do the effective date, delay it, and then the Senate can look into it a bit more. We're saying that we don't have a lot of timing to work out.
Or I could just bring this up in the Senate. I mean,
Well, the one I'd like to try to puzzle this out, because and I haven't gotten a final word on this, but a text to Chair Durfee, I asked if he had any input on this, on the animal cruelty bill, and he gave first jokingly say, yes, we've completely rewritten it. And then I said, okay, well, we are referring it to your committee. So he quickly backtracked on that joke and said, seriously, though, a couple of thoughts to share. And I've asked him if that means language. So I haven't heard back. So if agriculture does have a recommendation of some language and it's not too complicated, then this will be the penultimate version. So why don't we just puzzle this out a little bit more, Eric, if you want to kind of think of how we might change that.
Okay.
And if we do that, we can give Angela a gift of striking the other part, right? Which, I mean, so.
I mean, if everyone else agrees.
Well, no, I mean, so, yeah. Why, I'm going back to page 10, Eric, and line 12 and 13. I don't know why you can't just completely strike out remotely or within a reasonable distance from the defendant's residence.
Yeah.
Because this is kind of a voluntary, I mean, this part is. This is if you're trying to, let me see, no, it's not. Wait a second, let me see this. That's not voluntary. Are we telling them? Well, let me think for a second.
It's on
That's
the
why we
menu,
could just let the other.
it's on the
counties-
menu, you know, it's part of,
Okay.
it's one
Push it
of,
through.
it's one of the options.
Yeah, but you don't want the court to say you have to go to Brattleboro.
Right, it doesn't make, it's limiting, and I think
Right,
we're
it's limiting.
trying to be more expansive in
No,
where
no.
people can get treatment, right?
No, we're trying to keep the court from ordering somebody to get treatment in Brattleboro if they're in the Northeast Cape.
That's the other way to look at it.
That's the way I'm looking at it, so we're gonna keep going. We can debate that. But, yeah. So never mind about that. We'll just try to figure out the language on the page 21. And we'll find out hopefully from David Durfee very, very soon, since we're about to be on the floor, on whether they had anything besides thoughts on this.
Okay, sounds good.
All right, I'll be in touch shortly.
All right.
Thank you.
Perfect.
Thank you very much, Eric, and thank you, Lisa.
Thank you so much for all the work. I know
Thank
that
you.
you've done a lot.
I have a question about, well, we don't,
Is this an online?
You can go
it
off.
doesn't have to be, just a